Good morning. Today we're going to read a very serious article. Student Snapchat profanity leads to High Court speech case. And so this is our title, so we're going to circle that. And here they're talking about the First Amendment. So a Supreme Court case will examine whether public schools can discipline students over something they say off campus. The case will evaluate the limits of the U.S. Constitution's First Amendment. The court heard arguments on April 28th. Okay, so let's see what they have to say. When Brandy Levy was 14 years old, she did not make her high school's varsity cheerleading team. She went on Snapchat to express her frustration. She posted an angry speech directed at her school and the cheer team. The post contained some profane words and a profane gesture. Language or movements are profane when they are disrespectful or offensive. She made the post while she was at a store in her town of Mahole City, Pennsylvania. The team's coaches saw the post. They suspended Levy from school cheerleading team for a year. The incident resulted in the most significant case on student speech in over 50 years. It is currently being considered by the Supreme Court. The question before the court is whether public schools can punish students over something they say off campus. This topic is especially meaningful now. Many students are or have been doing remote learning because of the spread of the coronavirus. Also, more people are aware of the harmful effects of online bullying. The Supreme Court heard arguments on April 28th. Now, let's do this one. This next section is 1969 court case addressed students' speech rights. The case relates to a 1969 Supreme Court case, Tinker versus Des Moines. In that case, two siblings, Mary Beth and John Tinker, wore armbands to school. They were protesting the Vietnam War. Their high school suspended them. In a key ruling, the Supreme Court sided with the students. It declared that students don't lose their constitutional rights to freedom of speech or expression at the schoolhouse gate. Ever since, courts have wrestled with the details of that decision. Levy's case does not have the same motives as the Tinker case. Levy is now 18 years old. She is in college. I was a 14-year-old kid, she said. I was upset. I was angry. Every 14-year-old kid speaks like that at one point. When her parents found out about the Snapchat post, she said they were more worried about how she was feeling. They did not punish her. Instead, they sued the school. They claimed the suspension broke their daughter's constitutional right to free speech. Appeals court agreed with Levy. Lower courts agreed. They said the school must allow her back on the cheerleading team. An appeals court reviewed the case. Appeal courts, known as appellate courts, review decisions that courts below them have made. They said the decision in the Tinker case does not apply to off-campus speech. However, some groups said the appeals court went too far. These groups include the school district, education groups, President Joe Biden's administration, and anti-bullying organizations. The First Amendment does not completely ban public schools from disciplining students for speech. That happens outside the school. Elizabeth Prelogar wrote, "She is the law officer responsible for arguing cases before the Supreme Court." Philip Lee is a law professor. He has written about cyberbullying laws. He says it makes no sense to draw the line on policing student speech at the edge of campus. He said most cyberbullying is done off campus, on computers or other electronic devices. He and other education scholars wrote a statement calling for a more careful approach to regulating speech online. At the same time, you don't want a situation where schools are monitoring everyone's speech at home, he said. Should schools have to ignore disruptive speech? Lisa Blatt is the lawyer for Mahoney Area School District. Schools should not be forced to ignore speech that disrupts the school environment or invades other students' rights, Blatt wrote. Just because students launched that speech from 5 feet outside the schoolhouse gate does not mean it can be ignored, she continued. The school's approach would allow educators to police what students say at all times, said Witt told Vic Walczak. He works for the American Civil Liberties Union, or ACLU. The group is a civil rights nonprofit. It is representing Levy in court. That is super dangerous. Not only would students like Levy not be able to express non-threatening, non-harassing bursts of frustration, Wozniak said schools would also be able to perhaps limit important political and religious speech. I'm just trying to make a point, Levy said. Young students and adults like me shouldn't be punished for them expressing their own feelings and letting others know how they feel. Here's a question for you. Do you think your posts on social media should be considered part of your right to free speech as a student? Should schools be allowed to discipline students for what they post on social media? News ELA is taking student opinion submissions through May 24th. Send 100 to 300 words to editorial@newsela.com. Don't forget your permissions form. And there you go. Thank you.